A very good morning to one and all present here. My name is Jai Pankaj Botadra. I am currently in the final year of my 3 years course. I am a student of Government Law College, Mumbai. I am in B division. My this year's roll number is 6 and my previous year I held roll number 32. So my topic for this CRPC LVD presentation is what is bail and when bail can be granted in case of non-bailable offences. Now, to put it simply, what is bail? Author K.D. Gaur has done a fantastic job in explaining what bail is. So, bail is taking the custody out of the officers of law and entrusting it to a person who later becomes surety, as that person would be produced when the court demands or that police officer demands to do so. Now, when we consider the definition given under the statute, the CRPC didn't have a proper definition. There was no definition of bail under section 2. However, under BNSS, under section 2B, we have the bail term defined within our BNSS. Now, there are many types of bail. Recently, sir had discussed the same. But my focus would be on landmark judgments that discuss the type of bail. Now, Gurbaksh Singh case, Basia case, in that it was discussed that there are bail and anticipatory bail. The core difference between bail and anticipatory bail being that regular bail is granted after arrest, but anticipatory bail, as the term suggests, it is given in anticipation of arrest. Now, when we consider what changes have been done from CRPC to BNSS, there are two major changes. Firstly, the number has been changed, and secondly, there was this age limit which was in a sense exception. So there are 4 exceptions: a child under the age of 16, a woman, sick or infirm person, which was under CRPC. But under BNSS, the new legislature, they have just given the term child, but nowhere in the CRPC they have defined what a child is. So what we have to do is we have to check the substantive law, which is BNS, Bharatiya Nyaya Sanhita. Under BNS, they have defined child as a person not exceeding age of 18 years. So anyone below the age of 18 years is now considered as child under CRPC. And the exceptions of women, sick and infirm who are supposed to be granted bail are still considered under BNSS. Now, we have often heard what non-bailable case is, and we always wondered like how people are granted bail under non-bailable cases. So, despite the term non-bailable, it is just, if we dive deeper, we do realize that every criminal case technically can be granted bail, be it UAPA or TADA or any other such heinous act as well. It is just that granting of such bail requires discretion of a law officer. Now, that's the core difference what we have learned. Now, we have always come across that bail is right and jail is exception. Now, I would like to ask the class this question: in what landmark judgment was this established? Like bail is right and jail is exception? No, it is way prior than that. Anybody? Bail is right, jail is exception. It's a very common phrase. Yeah, but this is way back. So I'll just continue with my presentation. This was established by Justice V.R. Krishna Iyer in the landmark judgment of State of Rajasthan versus Balchand, often known as Balia. Jail is right, bail is exception. This principle was established that in a sense makes it mandatory. Now, the courts are of that view that bail is right, jail is exception. But when it comes to legislature, the wording of the legislature for section 480, which is bail in case of non-bailable cases, start with bail shall not be ordinarily granted. Now, this is in a way very diverse when we compare what courts have interpreted and what legislature intends. So, there's that huge diversion. Now, similarly, as I said, there are 4 major exceptions. Even if you commit a heinous crime or anything, if you are a woman, a child, sick or infirm, you are eligible for bail. Now that's the one of the reasons why those who commit heinous crimes are also seen, they are not in jail and they are given bail. Health is a very good exception which the politicians are quite abusing these days. Now there have been various landmark judgments which interpret bail as interlocutory orders. First is Amarnath Mishra case, then is Madhu Limia case. Now Amarnath Mishra case came first and it interpreted bail as interlocutory orders which is not subject to any revision. But in the later case Madhu Limaya, they said that it can be bail can be opted for revision, but bail can be granted for revision. But Madhu Limaya case refrained to comment much on the Amarnath case. So there is still this distinction. Now, my suggestion towards what BNSS could have been included was taking the liberty of granting bail outside the jurisdiction of police officers. It should be solely given to the courts, and because police is the authority who arrests for bailable cases. But similarly, if they themselves grant bail, then there is a chance that this power could be abused. Now there are various grounds under which the bail can be where the bail can be cancelled. Now if the person is out on bail but he tampers evidence, if he harasses witnesses, if he tampers with the process of investigation, now if such crimes have been observed being committed, such bail can be cancelled either by a higher court or the court granting the bail itself. It is open for both of them. Similarly, Gujarat and Bombay High Courts are of that view that those who grant bail also have the power that they can cancel same without even going to the higher court. Now, there is recent 2024 landmark case of Javed Gulab Nabi Sheikh versus State of Maharashtra, wherein Supreme Court played a very important role. Firstly, they said that the prosecution shall not deny bail or even make an application for the same if they can't promise a speedy trial. Now, trial isn't in the hands of prosecution, but Supreme Court still said that they should allow bail and they should not object bail. And if there is no speedy trial, then they shouldn't oppose having bail. Now, as to conclude my presentation, my suggestion is that they increase the age of child from 2 years. Like earlier under CRPC it was 16 years, but when we do consider the recent Pune Porsche accident case, we do realize that even increasing such age limit comes to is abuse of power and abuse of law. But what can be done is the bail should be discretion of the judge, and there shouldn't be any statutory limit as respect to age. What they can do is calculate the intellectual age of that person and the mental reasonability or rational of that person in order to grant bail. So can you please confirm the time? So if 9.5? Alright, I would like to conclude my speech. Thank you so much.